The Supreme Court just handed down what to me is one of the most dangerous rulings against not only the gun industry, but the Second Amendment.
In a blow to the firearms industry, the Supreme Court today denied an attempt by Remington Arms to block a lawsuit filed by the families of victims of the 2012 Sandy Hook massacre.
If your first response upon hearing that is, how in the world is Remington responsible for what some evil bastard did with a rifle? You're in good company. However, I need you to understand that this lawsuit is about money. The goal is not to win the lawsuit. The goal is to establish a way to sue gun manufacturers out of existence. They don't have to win the actual suit. They just have to be able to keep forcing manufacturers to fight ridiculous lawsuits, and they just found out a way to do it.
The suit argues that Remington, which owns the company that made the Bushmaster AR-15 style rifle used by the killer, was guilty of recklessly marketing the weapon, and that violated Connecticut's Unfair Trade Practices Act. They're saying Remington was somehow reckless in the way that it marketed these weapons to civilians. Please explain.
Yeah, under Connecticut law, there is a provision that allows prosecution of companies if they engage in marketing and sales practices that pose a direct danger. And this is the claim that the families are going after now, that the marketing of these weapons was manifestly oriented around the idea of their destructive capabilities. For example, there's a famous phrase or infamous phrase that was uttered and has been repeated that you can earn your man card by obtaining an AR-15. And it invokes not just manliness, but it suggests a kind of violence. It orients itself towards sort of the military utility of these weapons and the military derivation of them. And under Connecticut law, that is prosecutable.
This is why all of these anti-gun groups and anti-gun politicians keep using the phrase weapons of war or assault weapon when talking about the AR-15. The goal is to associate the AR-15 with only being a tool used to kill and not a tool used for self-defense or recreation. Then combine that with the media vilification of masculinity that's been shoved down our throats in the media, and you have the perfect argument to make any advertisement that has not only the AR-15, but any gun and any suggestion of masculinity a reckless call of violence. As a lawyer, the strategy is f***ing brilliant. As a two-way advocate, it's f***ing terrifying.
And I should add that there is a federal law that was passed by Congress in 2005 that was designed to provide immunity to the gun industry from such lawsuits, but even that law had a couple of exceptions, including an exception saying that if a gun manufacturer, for example, was found to have engaged in activity that is illegal, they could be subject to prosecution, and the Connecticut State Court ruled that this lawsuit could proceed under that exception in the federal law. And now, of course, the Supreme Court has said that the lawsuit in Connecticut can go ahead by not hearing the case appeal.
They love to gloss over this law to make it seem like gun manufacturers have complete immunity and can never be sued. This is not the case. The law he's referring to is the Protection of Lawful Commerce and Arms Act. It's a U.S. law that says you can't hold gun companies liable when one of their guns are used in crime. Before this law, people were suing gun companies and winning on the grounds that they should have foreseen that their product would have been used by criminals. Gun companies can still be sued for defective products, breach of contract, criminal misconduct, and any other action where they are directly responsible, just like every other U.S. based manufacturer or consumer product.
Back to this issue of these ads, though, help me understand. Walk me through the argument as it follows through. So the families are arguing that these hyper macho masculine ads that the company was running somehow entices people who are violent minded to buy these weapons, and that is somehow the problem.
Well, it extols the weapon's destructive capabilities.
Told you. Before the Protection of Lawful Commerce and Arms Act, the argument was you should know the guns will be used in crime. Now, after the act, they changed their argument to you're enticing young men with your toxic masculinity and weapons of war advertisements.
And certainly there is a great deal of firepower that accompanies a weapon like the AR-15. It is a semi-automatic weapon, but it can receive large capacity magazines. You can fire off a great many rounds.
Keep in mind, everything he said is true, not only of the AR-15, but handguns as well. Handguns are semi-automatic, and they can hold the same amount of ammo as an AR-15.
Medical professionals will tell you that they cause even more harm to the human body than other kinds of firearms.
The irony is, the bullet the AR-15 fires is less powerful than all of the so-called hunting rifle bullets they are seemingly okay with. I don't say that to demonstrate their lack of knowledge, but to show that once they get the AR-15s, they'll be coming for the hunting rifles next. And all they would have to do is show a picture of an AR-15 round next to a hunting rifle round, and it's game over for you hunters out there who think that your wood guns are protected.
And this kind of invocation, the litigants are arguing, constitutes an actual threat, precisely because the appeal is, oh, these weapons are so destructive, and therefore this is a violation of what they call in the Connecticut law negligent entrustment. And that breach, that claim, is the center of this lawsuit.
This is pure and utter lunacy. Negligent entrustment assumes Remington knew or should have known that the ad would cause a Sandy Hook shooter to steal his mother's AR-15 and kill 26 people. It's preposterous. But like I said, this is not about winning the case. It's about winning the ability to keep bringing these types of claims, forcing gun manufacturers to spend ungodly amounts of money to fight each one of them, whether they settle or take it to trial. This would single-handedly shut down the gun industry, and that's exactly what they want.
So the Supreme Court denied Remington's appeal. That means the case will go forward, as you were mentioning, in Connecticut. What do you imagine the likely impact this might have? I know there's an elaborate discovery process. What are the ripple effects of this case, potentially?
Well, I think there are a couple of very important consequences. The first, just as you mentioned, is discovery. It means that the plaintiffs will be able to get access to emails, company documents, other information of internal communications from Remington that could be at the least politically embarrassing or damaging, and at the most could actually contribute significantly to the weight of the lawsuit being brought against them. In addition, it will certainly embolden others to bring similar litigation. All states of the union have laws regarding consumer protection and advertising, and the laws in many of those states may not be appropriate for this kind of litigation, but it certainly will encourage others interested in bringing such suits to do so. It might also encourage some state legislatures to modify their consumer protection laws, perhaps to facilitate legal action of this nature.
And there you have it. He used a bunch of fancy words to say it, but he just said exactly what I've been saying. This is not about actually winning the case. It's about opening the door so that other people can bring the same types of cases, financially crippling the gun industry. The Supreme Court allowing this case to go forward is monumentally bad for the Second Amendment. This is a money game. These types of lawsuits are not altruistic. They are strategies employed by people with shit tons of money. They're not just attacking the Second Amendment politically, they are attacking it from all sides. They're attacking it culturally, legally, financially, you name it, and they have the money to do it. Bloomberg just spent millions by himself to turn Virginia blue. He has his own media company and billions to spend on influencing other media outlets to do his bidding, and he hates the Second Amendment. We can't outspend people like this. The only way to win this fight is to shift the culture. And the only way to do that is with messaging, which is why we have to inform and spread our message as wide and far as possible. That's why I'm always talking about you sharing not only my videos, but other people's videos on the Second Amendment. It's the only way, because trust me, this is monumentally bad for not only the gun industry, but also the Second Amendment. Right now, there's a culture war against the Second Amendment, which is why I need your help spreading our message to counter their message. You can do this by leaving a comment, sharing this video, and click the bell and subscribe button. Let my voice be your voice, and let them know you want to keep America tactical. Because the right to keep and bear arms shall not be infringed wasn't a suggestion, it was a directive. Also, if you're wondering where to get your I will not comply, I lost all of my guns in a boating accident, the AR-15 is protected by the Second Amendment, and your state-specific Keep America Tactical shirts, click the links in the description section of this video.